Hi, welcome back to I Now Pronounce You Divorced. Last week we were joined by Mr. Eric McCauley, who's here again this week, to discuss the holidays, custody and visitation issues with the holidays. And as promised last week, this week we're going to talk more about how you start planning on how to pass your assets from you to your family and start putting together the necessary estate paperwork to cover the fact that you're no longer married to your spouse. So, Eric, when you're thinking about testamentary gifts, how do you really sit down and talk to people as an attorney about the fact that they're going to die?
Well, I try to acknowledge that reality with the client first, that nobody likes to talk about their deaths. Nobody wants to contemplate how their life is going to end. So what I do is I try to put it in the context of thinking about those who are going to remain once you've passed away. Changing the focus to others as opposed to yourself usually is a little bit of a sea change for somebody where they're like, okay, I get it now. I understand why I need to be doing this. I want my children to be provided for. If you are married, I want my spouse to be provided for. I want to make sure that they're not kicked out of the house because I didn't have my will or other documentation set up. If you are divorced and you have remarried, you want to make sure that your assets are going to your current spouse. If you have a settlement agreement, which legally obligates you to provide benefits to your previous spouse, you want those to get set up so your new spouse is not dealing with an estate battle after you pass away. So, in short, change the focus to those who will be left behind and making sure that things are going to go to them as easily and quickly, as cheaply as possible.
As you're talking, I'm thinking that's great. And then how do we then continue that positive shift to explain to them what is a will, what is a power of attorney, what is a trust, and how does it apply to their situation, and what do they need? Because in my experience, clients coming in, they may know the word and the terminology, but they don't know the difference in the benefits. And there's a lot of nuances and a lot of different protections that it's really kind of attached to each one of those. How do you walk the clients through that?
Well, generally speaking, everybody kind of has a rough idea of what a will is. It's some document. If you recall from law school, some states will allow it to be handwritten on the back of a napkin, and others require other requirements where it has to be notarized and witnessed by at least two witnesses. Virginia has a general requirement, although there are exceptions like that. So I usually start at a point that I know they have some familiarity with, and I go with a will and I describe it to clients like a backstop. The laws in the United States over the past couple of decades have changed so much to allow people to pass on their assets without having to go through the probate process. Now, it used to just be that everybody said, okay, it's going to go through my will, it's going to go through probate, it's going to go through a 12 to 24, maybe sometimes longer month process, where my assets are just going to be viewed over by the court, and eventually it'll get to where they need to go. That is not the case anymore. So I'll start with a will and I'll say, look, this is your umbrella. This is your backstop. This is if you forgot something or if you acquire something later and you've not designated a beneficiary otherwise, the will is going to determine where it goes. People get that. And people understand a will is just, you're writing out a document saying this goes to that person, this goes to that person, sometimes splitting up shares. Generally, people can understand that. From there, I will then tie it into, okay, maybe you need a trust. Or if you own a house, Virginia passed, I want to say about 10 years ago, various laws which allowed you to do deeds on death for real estate. So a deed on death, for instance, the person who owns the house signs out on the deed, it gets recorded, they retain legal ownership in that house until they pass away, and immediately upon their passing, legal ownership transfers to the beneficiary. You don't need a trust. It doesn't have to go through probate. Now, if there is a mortgage or other kind of lien on the house, those still need to be dealt with. But the house, which for the vast majority of people is their largest, most valuable asset, now immediately got transferred to where it needed to go. So I try to describe to clients there are ways to get around probate that is sometimes can be as simple as filling out a form. If it's an IRA, a 401k, you can designate beneficiaries and the asset transfers immediately upon passing. You just present a death certificate to the plan administrator. You're going to save yourself potentially tens of thousands of dollars in probate fees and taxes, and sometimes 1 to 2 years worth of time of assets going through probate if you just fill out a 1-page form or a 2-page form sometimes. It's not that hard. And you get to retain ownership of it, and it goes to whom you want it to go upon your passing. So simplifying it like that for people generally makes them a lot more likely to actually do it, because, realistically, who likes to do homework? Who wants to go in and fill out pages upon pages of paperwork or review all of their assets? So trying to simplify it and make it a lot clearer and easier for somebody than they may have initially thought so is where I go with that.
That's great. As you were talking, I was thinking about I actually just had a probate case that finalized after 3+ years, and it was so simple. It was so simple. They were all adult children, everything was equal, everything else. But this person had just gone online on, getawill.com and typed something out and didn't make it very convenient for himself. How do you have the conversation about DIY versus an attorney, and what are some of the pitfalls that you've seen in someone trying to take care of it themselves, writing it on the back of a napkin, for example?
Oh, yes, great question. Usually how I address that with the client who comes in with a DIY will, or in divorce cases, settlement agreement or something like that, is I will read through it and I will point out specific provisions that make absolutely no sense or contradictory. I remember about 6 years ago, I had a divorce client who came in with a DIY settlement agreement. He had gotten it online, and it referenced the Virginia probate code, which we actually don't have in Virginia, and other various references to Virginia laws or equity laws, which simply did not exist. So maybe, whoever drafted that DIY template was from 20 years ago when our court system was very different. But we ended up having to go and get that settlement agreement interpreted by a judge because it was ambiguous. It referenced things that did not exist. And the same thing applies to a will. In Virginia, wills, you need either 2 witnesses or a self-proving affidavit to authenticate the will itself. So if you miss that, if you miss out on notary provision, if you don't understand what per stirpes means, you're just throwing in legal terms there, that kind of thing, then your will may not be actually worth anything. It may be rendered null and void if it's ambiguous enough, or it may go to a person that you don't want it to go to. In Virginia, you can omit presumptive heirs from your will, but best practice is not to just not mention them, but to specifically state, I am purposely not giving anything to this person, to this child, to this presumptive heir. That will help prevent or help you win an estate battle down the road. Again, you have to be thinking about those around you and making things as easy as possible for them.
Yeah, I think one of the things I'm looking for the most is all the presumptive heirs reading exactly what I thought about them in my documents. How do you discuss? We have wills and we have trusts, right? And each one, in my opinion, has a different purpose. Not my opinion. In law, they have a different purpose. But how do you discuss people after they've gone through a divorce, right? They've gone through a divorce. They have minor children. They have spent all this money successfully dividing up their assets, putting their children where they wanted their children to be put, or however their children are being, custody visitation being set. How do you discuss with them, like, hey, now more than ever, you need something, because if you pass away, tell them what happens if they pass away with nothing after a divorce with minor children.
Mm-hmm. Again, goes back to my first point of what's it going to look like for your children or for your new spouse if you get remarried if you don't get this set up. So setting aside even wills and trusts for a second, powers of attorney, advanced medical directives, those kinds of things, especially while you're in the separation period and not divorced yet, and you're still legally married. I have seen cases where the spouse that my client is getting divorced from, if my client goes in the hospital for some reason and is in a coma, cannot respond, will walk in and say, I'm the wife or I'm the husband, which is true, but they won't mention to the hospital that they're going through a divorce. And the hospital is normally going to default to the spouse if any medical decisions need to be made and the patient cannot consent or otherwise indicate what they want. So having a power of attorney set up even during your separation period is crucial. Nobody thinks that they can get into a car accident or something terrible is going to happen to them until it actually does. So do you want your spouse who you're getting divorced from to have the authority to pull the plug on you if you're in a coma? So I usually put it in those terms when it comes to powers of attorney, advanced medical directives, and powers of attorney. Also, if they are durable powers of attorney that are currently in effect, you have given your spouse the legal right to access your financial accounts and make decisions on behalf of your estate. So depending on what those are, that could be selling real estate, that could be transferring funds from your bank account to another bank account, withdrawing funds from a retirement account, that sort of thing. So again, do you really want your spouse who you're getting divorced from the ability to run your estate and your assets and do whatever they want with them without your permission or knowledge? For wills, trust, testamentary vehicles like that, I usually put it in terms of, okay, you just got divorced and, your spouse no longer has these presumptive, household allowance claims or these sorts of claims against your estate because you're now divorced. But if you don't have a will set up, if you don't have some kind of testamentary plan set up, and you have minor children, and then your assets are going to pass under what's known as the intestacy laws that Virginia has. Now, if you're not married, your presumptive heirs first are going to be your children. But if your children are minors and you're divorced, you're not remarried, you are now essentially giving your ex the ability to handle those assets on behalf of your children while they are minors. And who knows what they're going to blow that money on. I've dealt with cases where we have seen child support, instead of actually used to feed the children, is used to go get $300 hair appointments, that sort of thing. So if $500,000 is just going to fall into the lap of the other side, you want something in place that specifies this is how the funds are going to be used. So as you've referenced, a trust could be that. A trust is a testamentary instrument where you can designate somebody else who has, well, not themselves, but they oversee ownership and distribution handling of assets that you've put in a trust. You can put real estate in a trust. You can put retirement funds. You can put cash. You can put vehicles. You can put most assets into a trust. And you can specify in the trust how those funds are supposed to be used, how they can be dispersed and distributed, and for what specific purposes. So you've heard of probably like spendthrift trusts or education trusts, things like that. You can say, okay, so my brother is going to be my trustee, and these funds can be distributed on behalf of the minor children only for private school tuition while they're in high school or elementary school, and then college tuition, room and board, books, that sort of thing. And if there are any funds left over by the time that they've graduated from college or hit the age of 25, 26, then the remaining funds will be distributed to them directly. If you have something like that in place, your ex-spouse never gets control of those funds and can't do anything with it. You can specify that the trust has to make the payments directly to the school that the children are going to, instead of money to the ex-spouse, and she or he may not actually pay it to the school. So again, putting it in context of, do you want your children provided for? Do you want to make sure that they're still going to be able to go to school where you want them to? Then you should set up these kinds of instruments.
For those who are tuning in and they listened to the first episode, and we're very appreciative you come back on the second one and really talk about an important topic, those going through a separation or divorce and they already have a power of attorney or a will, how hard is it to change it? Because I'm sure they're thinking, oh my gosh, I got to change this because Erik is saying, I don't want my soon-to-be ex-spouse to pull the plug on me or to, spend all our money or give away all of our assets. How do you go about changing them?
It is extremely easy to change them. You simply execute a new one. And in the power of attorney or advanced medical directive, which are also sometimes called living wills, which is different from an actual will, you have one or two lines in there which say that I revoke any and all previous powers of attorney or advanced medical directives that I have executed. If you know that those powers of attorney or advanced medical directives have been provided to any other institutions, such as banks, because banks will keep copies of the power of attorney on file if they've been proffered to the bank before, then you provide the new updated copy to that. So your ex-spouse can't come in and rely on the old power of attorney. These powers of attorney are dated if they're done right. They'll have a date from when they're executed, a date of notarization, date when they're witness, that sort of thing. And also the best types of powers of attorney will also have the name and contact information, so phone number, email, and addresses of the new agent. Banks are pretty good about scrutinizing powers of attorney. I mean, some are. And if you have that contact information in there, they can contact the other agent and say, hey, we just had somebody else come in and they're claiming to be the power of attorney, but you also have one on file. What's the situation here? So they're very easy to execute new ones. And then you just provide them to any institutions that you've provided before. Most people haven't. So sometimes it's just as simple as executing new ones.
And so if someone is at the beginning of their case and they're also trying to consider the estate planning side, what does kind of the flow of that look like? Do I start my divorce first? Do I start my estate plan first? Do I do them at the same time? Like, what does that timeline look like?
It's going to depend on the nature of the situation. Sometimes there's an urgency to need to get the divorce filed first. Maybe the other side is threatening to leave the state with the children. So that necessitates having to file that divorce complaint and get a temporary custody hearing filed as soon as possible. But generally speaking, if there isn't anything super urgent going on, you would at least want to update your power of attorney and your advance medical directive. Updating something like your will, your trust, those kinds of testamentary instruments is helpful. But Virginia allows for a spouse who has even been cut out of a will or a trust, as long as they're still legally married, they can make various claims against the decedent's estate for certain percentage values, typically between 20 to 30% ish of the value of the entire estate. So if you're still legally married to somebody, and you have purposely omitted them from your estate plan, your will, your trust, whatever else you may have, they can still make a claim against your estate in court. So sometimes that will lead to the strategy of we will try to get clients divorced quickly and reserve remaining issues to deal with for later adjudication. Because if they're divorced, then those kind of marital claims against the estate die with the marriage. When I was a relatively newer attorney at a previous firm, I actually set appellate court precedent on that. We managed to get a very wealthy client in Norfolk, owned a lot of properties, divorced first. He was a lot older. I think he was in his 70s or 80s at the time. We got him divorced, reserved equitable distribution and spousal support. And before those could be dealt with, he passed away. So then it became an estate claim. And we managed to preserve his estate from those automatic claims because we at least got him divorced first. So you generally want to do your power of attorney, advanced medical directive. But the other stuff, while it's good to update those, I typically advise clients to do so after they're divorced. So there's also no confusion as to, well, you executed these while you were married, you're no longer married. If there's no urgency, then I generally advise them to wait until after.
Yeah, I like estate planning during divorce. I kind of like what you said. Do you really want your soon-to-be ex-spouse making decisions? I always told people, look, you obviously don't like each other. Why would you trust them to make the right decision right now? Estate planning, I think, goes hand in hand with what we were talking about with planning for the holidays, because it takes proper planning to prevent poor performance. And we're talking about testamentary gifts. It's really important to talk about to your family, and it's easiest to do it during the holidays when you're maybe sitting with them. So Erik, I want to thank you for joining us. If you like this episode, please click like and subscribe, and we look forward to talking to you all next week. Thank you very much.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.